Welcome to Vertex Technopreneur Webinar Series session number 6. This is a continuation of a session number 3 where we talk about some of the legal terms and things you need to look out for as a founder when you're raising a financing. Next page, please. Before we begin, there's a couple of housekeeping matters. This session is recorded. If you experience any technical issues, please log out and log back on. And feel free to submit your questions using the button below. And of course, always give us your feedback after the sessions. We will really like to hear from you. Next page, please. So this, like I mentioned, this is about webinar series session number 6. Next page. We have two very good speakers like the last time. The first speaker is Chan Hyok Choi, who is a Director of Investments at Vertex Growth Fund. Hyok graduated from National University of Singapore with a law degree, and then after that he joined Allen & Gallagher as a lawyer and joined us last year as a director of investments at the Vertex Growth Fund. Today he focused on investing in global opportunity in technology sector. Second speaker is Kevin Chua. He's a managing director at Research Partners. Kevin, like Hyok, also graduated from National University of Singapore with a law degree, and went on to join Allen & Gallagher as a lawyer and joined Vertex Growth Fund as a period of time before he took out his recent position as managing director of Research Partners. Research Partners is part of a Japanese company, the NEC, focusing on private equity and mezzanine financing. Next page, please. Like I mentioned earlier, this is a continuation of session number 3. Today, the two speakers will be focusing largely on the 3 remaining items, focusing on some of the transfer restriction and IPO matters and also other due diligence related matters. But because the last session, there's a lot of good questions posted by many of you, and we did not have a chance to answer many of the questions. So today, before they go on to present many of the session number 4 and 5 and 6, they will cover some of the questions that are raised by many of you, and to answer many of the questions. With this, I'll hand over to Kevin.
Thanks, Kilok. So just a quick recap of session 3. So we covered various topics in session 3. I will not go in depth in this session, but if you're interested, feel free to reach out to Vertex or myself or Hyok for the video recording. So first, in session 3, we talked about the general considerations and practical tips when it comes to closing a deal. We talked about the difference between equity and debt instruments. So equity, on the equity side, we talked about warrants, ordinary shares, and preference shares. On the debt side, we talked about the safe note, which is a simple agreement for equity, a convertible bond, as well as venture debt. And then we compared the differences between these two from a founder's perspective. Then we went on into more technical details about key terms when it comes to the legal documentation. So first category of terms we talked about was economic rights, such as liquidation preference, anti-dilution, and preemptive rights. And then we also went into talking about control rights, such as reserve matters and voting. And also in this session, we talked about some practical tips, as well as the process for closing a deal. So on the right, you can see a summary of the process. And we also talked about the practical tips to deal negotiation and how to deal with lawyers to keep your costs low and the process efficient. So now to cover some of the questions that came up from session 3 that we were unable to cover due to the lack of time. So first question is to give an example of SAFE and the potential dilution risks in the next round. So here we created a sort of a model to illustrate the dilutive effects of the SAFE note. So it's also quite technical, so I will not go into the details of how to calculate the formula for calculating these dilution. But here, this is an assumption that the company raises a 1 million round for SAFE, and then they're now raising a Series A post-money valuation of 10 million. So here we modeled 3 scenarios. First, 50% discount. Next, 5 million pre-money valuation cap for Series A, and then we compounded both scenarios together. So you can see that for the first 2 scenarios, it's highly dilutive for the founders, especially at such an early stage of the company, even before raising a Series A round, for quite a small amount of money raised of 1 million. Then you can see it's compounded if you give multiple onerous terms to safe investors and many other various terms that we have not illustrated here on this slide. The key issue here is that for founders, if you were to agree to these terms now, you will only feel the effects later on when you actually raise a Series A and you raise an equity round. So the dilutive effects of what you agree now during a safe round will only be truly felt when you raise an equity round and when the valuation, the round size, and the total outstanding shares is decided at that point in time. Moving on.
So moving on, for a founder, I think sometimes you might ask whether you should get the lead investor's comments or every investor's comments on the documents. So actually there's no fixed arrangement, and if there are many investors coming in at the same time, actually the common arrangement is for the lead investors or their lawyers to actually be the ones gathering the comments from the investors. So but from the founders and key employees, you will be the ones gathering the comments from the existing investors' side. And whenever there's comments, you should actually copy all investors on the same thread, existing and the new investors, and then the lawyers will be in charge of responding.
Next, would it be safer to use standard care terms for early fundraising or to minimize onerous terms for subsequent rounds? Okay, before we go into answering this question, I think I should explain what a CARE stands for. CARE stands for Convertible Agreement Regarding Equity. And this is the term adopted by the Singapore Venture Capital Association for their model agreements, whereas in the term SAFE is more commonly used in the US. But to answer the question, the short answer is that it depends. It's safer to the founder from the perspective of their minimal terms, and it's not an equity instrument that would give voting rights, control rights to the investors, etc. Hence, it's less likely to lead to onerous terms later on. But as discussed earlier, the risk to the founder is dilution. Also, I would mention that for larger venture capital firms and investors, we rarely have seen them invest using a SAFE or CARE instrument, because when they want to invest, they want to have control and voting rights to minimize their downside. There are generally limited investors such as Y Combinator, who is the one who originated this instrument, that will invest via a SAFE or CARE instrument. Next question, how reliable is an NDA, and if a party disclosed my confidential information, how will I prove my case? So technically, NDA is a legal binding agreement that can be enforced in court if there's any breach. But as the question alludes to, proof is difficult. You will have to prove that it was in fact the other party that leaked the information, and you will need some tangible proof. But that being said, as a sort of soft deterrent, a written legal binding agreement can serve as a deterrent to all parties to the NDA, because there might be potential legal liability if they were to leak any confidential information. But in general, what we have seen in practice is we rarely see parties suing on NDA in VC transactions, because it's troublesome to gather proof, and it's a costly process which may not be worth the compensation that you'll be able to obtain out of the legal suit. Next question, in ESOPs, is it normal to have tag and drag rights? The answer is no. There's typically no tag and drag rights because first, they're ordinary shares, and then they represent a small stake in the company. And the key of granting an ESOP is, the key rationale of granting an ESOP is mainly to incentivize and reward your employees for their hard work. So, but we also mentioned that generally preferred shareholders and founders will have drag-along rights over these ESOP ordinary shares. What's the typical range for ESOP pool? And is it safe to assume that all investors want this to be included pre-money and will not budge? So we'll say to the first part of the question, there's no definite answer, but typically the range we see is 7 to 15%. But in later rounds, you need to bear in mind that the percentage will likely be smaller because you have a bigger pool of outstanding issued shares. And typically, we will advise founders to, rather than thinking about what's the typical range, but think about the ESOP plan and the absolute number of shares available to be issued to your key management under the ESOP. And on the second part of the question, it's safe to assume that most founders will ask for a pre-money increase, but we also advise founders, instead of thinking about this, whether it should be pre or post, you should discuss with investors about the valuation. Because if the investors feel that the valuation is too high, it's likely that the investors will ask for a pre-money increase. But if the valuation is fair and the founders are able to give a convincing reason to justify a post-money increase, then we believe that investors should be open as well. Another preemption right name is right of first refusal. So on this, no, because legally it actually refers to both the rights, it refers to the rights to preempt or act before shares are issued or transferred. But in the VC context, what we often find is It's most often commonly used by investors to refer to the rights to act before shares are issued, not transferred. But we just wanted to highlight this in the previous session so that founders and parties would just bear this in mind, because this term can be used to refer to different things by different people. Next, what's the typical threshold to offer a board seat? Well, there's no definite answer to this question as well. It really depends on the situation and the cap table. In early stages, when there are few shareholders, perhaps there may be no threshold, or the threshold may be higher at around 10%. But at later stages where there are more investors, including minority shareholders, then the threshold will likely be lower to reduce the board size. We generally advise founders to think of this rather as whether there's one director representing each series of shares, so that they have someone to speak up for their rights for the particular series.
So what are information rights? What are the information rights when you only have a convertible note at hand? For convertible notes, it's common to have information rights, but it will be fairly minimal. So it's usually limited to the monthly, quarterly, and audited financial statements, and sometimes annual budget. What should I do if the lawyer gives me a bill which exceeds the amount that I agreed with them? So this goes back to the earlier session, which we mentioned the importance of agreeing with a fee cap with your lawyers, so that at any point in time, both lawyers and the founders would understand that this is the maximum that the fees can go to. But there are times where the deal becomes very protracted and the lawyers might incur quite a substantial time cost over and above the fee cap agreed. So our advice is that if the founder actually senses that the deal is protracted, like there are multiple terms of documents with many complex bespoke terms, then it's actually always good to check in with the lawyers for an update on the time cost when this happens. And when you guys are very near the time cost or limit, then it's good to then manage the legal process more efficiently, like going to the lawyers only for legal points and not on the commercial matters. But if in the event that the bill has arrived and it's over and above the post-investment side, you can then try to negotiate a discount on the fees on the basis of goodwill. The typical discount that we see is usually 10 to 15%. So in this section, we will go through the transfer restrictions and other terms which would serve as part of the investor protection suites or other terms which the founders would be concerned about. So like the first session, we will also highlight why these clauses are put in place, how these clauses work, and how to actually think about these clauses from a founder's perspective. So the first clause is the automatic and mandatory conversion. So the conversion right, actually, there are two types. So the first type is automatic, and the second type is mandatory, and you usually see it in the shareholders agreement. The automatic conversion right is actually usually triggered when a company decides to go IPO. And this is because a company can only IPO with ordinary shares. So in the event that the board and shareholders decide that an IPO will be the path to exit, then all the investors' preference shares will then convert to ordinary shares just before the listing of the shares. Therefore, there's this clause to provide for this scenario of automatic conversion. But that said, it's also very common, just related to this point, it's actually very common for investors to want to include this concept called qualifying IPO value. So what this means is that the company can only IPO once it crosses this particular value. And if in the event the IPO crosses, or the listing price crosses this, proposed listing price crosses this value, then shareholders cannot actually vote to say that you don't want to proceed with the IPO. The other conversion right is a mandatory conversion right. It's actually triggered by a vote of shareholders. And the reason for having this clause is actually to cater to the event when shareholders decide that an IPO will still proceed, even though it's below the qualifying IPO value. So from a founder's perspective, what we will advise is that you should, as far as possible, try to make sure that the thresholds for conversion rights is the same for all classes of shares, and the shareholders should vote as a single class, meaning there should not be multiple classes of shareholders voting to convert, because it will overcomplicate the process and it could hold up the potential IPO. So another term that for investor protection that is quite hotly contested would be the warranties and representation section. And this is usually a very long list of a couple of pages of clauses which act as a guarantee to investors on certain matters. And the rationale is really for investors to, is the rationale of having this clause, or at least why investors would want to have it, is because they invest on the representations and the information given by the founders. So in light of that, it's even more important for investors when they to have this clause, so that there is some form of guarantee. If in the event that there are clauses that there is warranties which you do not want to give, not just outright rejecting is actually not a good reason, and actually it could send a potential signal to the investors that there's something more to be uncovered. So one way to actually, in the event you are unable to give the warranty, you should actually disclose it in a separate document called the disclosure letter. So meaning that you warrant the warranties, but except for these disclosures made in the disclosure letter. Kevin will cover this disclosure letter portion at the later parts of the slide. So if you look at this slide, it actually shows a list of warranties which investors usually expect from the company. As you can see, it will center around the information provided by you to the investors, such as financial statements, ownership of IP and its assets. They would also, of course, want warranties on the state of your company, like insolvency, litigation, compliance with laws and insurance policies, PDAP, etc.
Now I'll move on to talk about drag along, some of the transfer restrictions found in the legal documents. So first off is the drag along right. This typically comes up when there's a potential acquirer that wants to buy 100% of the company, and it will usually be given to the preferred shareholders and founders to vote by majority to force all other shareholders to sell their shares. The main rationale for this is that it will prevent minority shareholders from blocking a transaction and refusing to sell. This is especially important because some later stage investors who invested at a higher price and may not have achieved their return multiple may block a potential deal. So, say for founders, this will also save founders from agitation and trouble when they want to exit the company. So a couple of points from the founder's perspective. So first, you have to consider the approval threshold to trigger the drag along right, and this should not be too low to trigger. And one key point to take note is no single investor should have the sufficient shareholding to block the deal. Otherwise, one investor will have the veto right to prevent any exit. And founders should also consider including ordinary shares to be counted. The most common mechanism for doing this is to vote on an as converted basis. This is so as to prevent preferred shareholders from voting amongst themselves and forcing all shareholders, including the founders, to exit prematurely. And next, also to tap to the minimum safe valuation to trigger the drag along to prevent a premature exit as well. And this is especially important when the company is not doing well and when shareholders are having trouble exiting. This is when parties might try to seek and enforce drag along right. And as mentioned in session 3, one of the practical tips for this is to think of the long-term consequences and the worst-case scenario when you're negotiating your drag along rights. Co-sale rights. This is usually given to only preferred shareholders to sell the shares alongside other shareholders. And the rationale is because it's usually triggered when the founders want to sell their shares, and this will allow investors to exit along with the founders. And this mainly is to provide protection to the investors when the founders want to exit the business. And sometimes it may also be over the sale of controlling interests by an investor, which can affect future exit options, especially if the investor has a controlling stake over the company and other investors do not want to be stuck. At the later stages, founders should consider that only major investors will have this right to ensure that not too many shareholders will be able to participate. And generally, these rights would be on a pro rata basis, meaning the total amount of shares willing to be sold by the founder and co-sale sellers will be distributed based on the total number of shares that the buyer wants to buy and their respective shareholding percentages. As discussed earlier also, usually only ordinary shareholders, ordinary shareholders and ESOP holders do not have co-sale rights. Founders may also want to consider whether to build in exclusions such as selling to affiliates or their family members, or up to a particular threshold, so that this will allow founders to have some cash liquidity from selling their shares. On the right of first refusal and right of first offer, so this is quite a technical slide. So the right of first refusal, ROFR, is, and the right of first offer, ROFO, is actually similar rights, but the key difference is in the process. So generally, these two rights are rights for shareholders to buy the shares of another investor who wants to exit the company. And as mentioned, the key difference is in the process. For ROFR, the right of first refusal, if the shareholder wants to sell their shares, they must first go solicit for third-party offers first. Whereas for the ROFO, if they will offer the shares to the existing shareholders first before they can go out and solicit for third-party offers. And they will offer the expected price and terms that they want to sell it to the existing investors. And if all the existing investors do not accept the offer, then the seller can go out and find a third-party buyer. For the ROFR, once the selling shareholder has received a third-party offer, the other shareholders will know who the third-party buyer is, and they have the right to purchase the shares from the selling shareholder on the same price and terms offered by the third party. This would mainly prevent, the intention of which is to prevent founders or major share investors from selling shares without letting the other shareholders an opportunity to buy, especially if it's a third party that they do not want to become a shareholder or work with. But the price offered by the third-party buyer for a ROFR is likely to be higher and closely reflect the fair market value of these shares. Whereas for the ROFO, the rationale is that it's likely to be a shorter process if the existing investors are willing to take up the shares, and in turn it will be less costly. However, the price that the seller will be able to obtain here might be a lower price, and existing investors would tend to have more control over the process and the terms of the sale. So also, we also advise founders to also consider the co-sale rights and drag-along rights when thinking about this right of first refusal or right of first offer, because the buyer may scrutinize the documents in deciding whether they want to buy, and existing investors may also have a right to co-sell the shares with the founder, and in turn, the founder may not be able to sell all of the shares that he initially wanted to. So from the founder's perspective, there are similar considerations for both of these rights. It's to ensure that shareholders do not want to work with or brought on board. And in later stages, founders may want to consider only giving major investors this right. And typically we see that this right of first refusal and right of first offer is on a pro rata basis. We rarely see a super pro rata right. And founders should also consider whether to create exceptions for transfer to affiliates. This is sort of beneficial to investors to allow them to transfer within their related companies. And as a general point to sum up this transfer restrictions portion is for founders, we advise to keep in mind, you should not allow any transfers for any shareholder other than to affiliates, and in accordance with all these transfer restrictions that we have just talked about. And this is so as to ensure that founders have control over who are the shareholders and who they work with in the coming future.
So founders are integral to an early stage company. So much so actually that the founders themselves form part of an investor's consideration as to whether to invest in a company. Therefore, it's actually very common for investors to want to include clauses relating to the founder. And one such clause would be the founder lock-up clause. So what this does is it will prevent founders from actually selling their shares for a limited period of time unless consent is sought from the investors. We usually see a 3 to 4 period lockup. And the follow-up question that founders might have is whether are they able to monetize some of these shares before these 3 to 4 years. For such scenarios, you could actually include clauses which stipulate that the founder is able to liquidate a portion, usually a small portion like 5 to 10%, at a time period earlier than the lockup. The other founder clause is the key man clause. And what this does is it will ensure that the founder devotes 100% of his professional time and energy to the company. Likewise, given that we mentioned that the founders are important, this is something that investors expect. And our advice to founders is that if you have any other business interests, it is best to declare them upfront to the investors so as not to be caught up by this clause. While there could be potential workarounds by the investors, we emphasize that it's actually common practice for investors to expect the founders to be 100% committed and not be distracted by other business interests. For pay-to-pay clause, this clause would only be triggered in a down round where existing investors have to participate in the down round. So if these investors do not participate, if these existing investors don't participate, then they actually lose certain rights like anti-dilution rights or the right to participate in future rounds. The rationale for this clause is really to just make investors support the company even in harder times when there's a down round. So from a founder's perspective, at first brush, you might think that actually this clause may be useful because your existing investors will have to continue supporting your company even in the difficult times. But our view is that this clause is rarely included, and we do not recommend having this clause for the following reasons. So the reason is because it has an effect of restricting investors from coming in. These are usually smaller funds or individuals who actually lack the funds to follow on in subsequent rounds, even if the round is not a down round. So they might be turned away after seeing this clause because they could be unfairly penalized just because they do not have the funds to follow on even in up or down round. So this is something that they would be turned away, and we do not recommend having this clause. So there are a couple of other minor clauses, but still very important. For the investors' expenses clause, this is the fees in which companies will reimburse the investors for conducting the investors' legal or financial or whichever due diligence. So from a founder's perspective, you should look out for a couple of things. The first is the cap on the expenses. And then secondly, the expenses must be reimbursed only upon successful closing. So, and it's more common for investors to only be reimbursed when there's successful closing. So the next clause is a non-compete clause. So this is something that investors might include to require, they could require the founders to actually enter into separate non-compete agreements such that the founder cannot engage in other business if he leaves the company or solicit the employees from the company. So if such clauses have to be included, we recommend that as a founder, you should ensure that the scope of this clause is limited, so that so that if you leave, you are not barred by this clause, and there is a fair time limit on this clause. And in any case, you can also refer the investors to the employment contract if the contract has such terms. So the last clause on this slide is the no competition clause. Some founders might actually want to include this clause, which stipulates that the investor is not allowed to invest in other companies which can compete with the founder's company. So our recommendation is actually they should not include this clause because it is not standard and it's actually not uncommon for a company to pivot away from its original business. So when it pivots away, the VCs may have actually existing investments which might end up directly or indirectly competing with the company and therefore be in breach of this clause. So when they see this clause, they will likely strike it down in the legal negotiation. For the variation clause, this seems like a simple clause. It's actually very important from a practical standpoint. So this clause actually stipulates that a company can only amend the shareholders' agreement as long as shareholders above a certain percentage agree to this new agreement. So the importance of this clause is actually twofold. The first is that especially if you have a long list of angel investors or when your cap table has become too long in later stage financings, it would actually be logistically easier for you to execute your agreements because you don't have to go to every investor to get their signature. All you do is just go to the investors which exceed that certain percentage. Secondly, the more important reason would be it will prevent a situation of holdouts by minority investors who actually do not want to agree to the new shareholders agreement. With any holdout, you actually would not be unable to execute the shareholders agreement and you cannot complete your current financing round. For the next clause we have is the invention and assignment clause. So this is something that an investor might ask, especially when your IP is not owned by the company but owned by the founders or the employees. So you should actually, then they will have this clause to such that the IP will be then transferred to the company, since the investors will be investing in the company itself. So you, as a founder, you should try to have this in place, or rather try to assign all your IP to the company before the fundraising, as it will definitely be one of the questions investor would ask if your business has intellectual property. So when negotiating the term sheet, there will also always be a no shop or exclusivity clause. What this does is that it would prevent the company from negotiating with other new investors. To the investors, it's actually crucial because they have actually expended time and energy negotiating with your company and doing due diligence. So they would, of course, want an exclusivity in mind. But as a founder, when you see this clause, there are a couple of things that you should look out for. The first is that there must be a fixed time limit on this exclusivity. What we see in VC fundraising is 6 weeks, or could be longer if it's a later stage financing. The second is that the exclusivity should actually expire when the investor terminates this clause, this process, so the company can actually go out and continue their fundraising. The third is that if an investor actually says that they want liquidated damages if this clause is breached, this is something that you should reject, as it puts an onerous amount of liability on the company. The last thing that you should look out for is that if your company is very late stage financing, where there could be a potential M&A that takes place along with the financing, then you have to include a specific carve-out for any incoming acquisition in the event the M&A comes in during the exclusivity period.
Before we continue, there are a couple of questions relating to agenda number 4. I think the first question, I guess, is for Kevin. Do founders always get dragged along in co-CEO rights?
Well, for drag along rights, yes. Founders generally get, all shareholders, including founders, would have drag along rights. And every shareholder will participate in the vote on whether to sell 100% of the company, because the end result concerns everyone as a shareholder. Whereas for co-sale rights, typically only the preferred shareholders or investors will have these rights. The main reason is because investors do not want to allow founders to co-sell their shares and exit the company whenever any shareholder or investor wants to exit. They want the founder to be committed to the business.
Okay. Next question, I guess, is for Hyok. This is relating to, I guess, warranty. Must I give the warranty on accuracy of information? Some information may be given by my employees, and it is not possible for me to check whether all information is accurate.
Okay, yeah, good question, actually. The starting point is that there's no warranty that you must or must not give. It really is down to negotiation between yourself and the investors. But as mentioned earlier, if you do not give, you actually need good reason not to do so, because it might send a signal to your investors that there's something that's not accurate. So, and actually, if you take a step back, the reason why investors want this warranty is because they rely on your information to decide on the opportunity. And if the information that you provide is knowingly wrong, the investor will invest based on wrong information. So they need a warranty for that. But to counter any founder's concern of potential liability in the event there's misinformation not within your control, then actually there are a couple of things that you could do. The first is you could add qualifiers like knowledge. So for example, to this warranty itself, you can say, like, to the best of the founders and key employees' knowledge, you warrant that this information is true, and etc., etc. And the other potential way you could deal with this is that you could limit the information to only material information. So you only warrant on the material information and not on every small little information that you provided to your investors.
Okay. Next question, I guess, is for Kevin. I think it's relating to right of first refusal again. Should founder use right of first refusal or right of first offer, and what is better for them?
This is also a good question, because actually there's no right or wrong answer to this. It really depends on the situation. It really depends on whether the founder values speed or value. because for right of first refusal, it's likely to provide optimum value price for the founders, whereas for the right of first offer, it's likely to be quicker. If I mean that's to say that you are able to find a third-party buyer if the existing shareholders reject. But at the end of the day, I guess process-wise, to the founders, it should be pretty much the same, because if the investors don't exercise either right, the founder still has to find a third-party buyer.
Okay, maybe I'll take one more last question. This is relating to this for Hyok, I guess, to no shop exclusivity clause. For the no shop exclusivity clause in the term sheet, can I also enforce on the investor such that he cannot negotiate with my competitor when negotiating with me for the financing? Yeah.
Okay, actually, yeah. Well, most clauses are supposed to be fair to both founders and VCs. Unfortunately, for this clause, exclusivity is only one way. So while your company can only negotiate with the investor exclusively, the investor is actually not bound by exclusivity, and he could give out many term sheets at one time, even to your competitors. So to really counteract that, that's why we mentioned that the period of exclusivity is very important. You should really keep it to 6 weeks. So if he cannot complete his due diligence or make up his mind by then, the time period, by the time period, then the company should be allowed to consider other term sheets. And the other point is that it would be also very important to do checks and due diligence on the investors that you are receiving a term sheet, because generally for good VCs, they do not work with 2 or more companies at the same sector concurrently. Of course, there are some who do this, but the good VCs, they would not negotiate with 2 at the same time, usually.
And with that, maybe we can continue item number 5 and this one. Okay.
So for item number 5, this section we will go through the IPO terms and the concepts relating to IPO. So the first term would be the registration rights. This is rarely seen in a Southeast Asian context and more common for US companies, but it could be relevant for a Southeast Asian investor when you move your operations or want to set up shop in US. Under US regulations, it is actually difficult for investors to sell your shares to the public, and you'll be subject to certain restrictions. So with these registration rights, it actually gives investors a right to exit the company by selling the shares to the public. And there are 2 types of registration rights. The first is demand registration rights. So this is when the investor can actually force the company to register the shares and sell the shares publicly. Then the second would be piggyback registration rights. This means that the investors can actually exit only if the founders are willing to commence the exit process. So of course, the piggyback registration right is more restrictive because you have to wait for the company to initiate the process. But in general, from a founder's perspective, what we wish to highlight that these clauses are rarely invoked, and actually they are actually fairly standard. So you need not push back, as it's not detrimental to your interests. Another common term that you see is an IPO lock-up. So what this clause does is to make sure that the investors agree not to sell the company shares for some time after the company goes public. The time period is usually 180 days. And the rationale for having this clause is really so that investors do not later push back on any potential lock-up arrangements when the company, investment banks, or companies or investment banks want or ask for a lockup on these shares from the investors. So at this juncture, perhaps a common question to ask is what will happen to the VC and your shares at IPO? And actually, there are some common concepts here. The first is that for VC and founders, you will want to monetize at IPO by selling your shares to the public. So, but as a founder, there are a couple of things to look at, to think about. And the first is that as a founder, you would typically not want the VCs to sell too many of their shares, because what you want is to actually prefer to raise new money from the public and not to let the existing investors sell their shares. This is also one of the main reasons why you want to go to IPO, which is to actually raise more money from the public market. The second thing to think about is that investment banks actually may not want VCs and you to sell your shares at IPO, because it actually sends a signal to the market that you are abandoning ship. Then this will be very difficult for investment banks to actually go out to raise money. Another concept to note, as mentioned, is the IPO lockup. It's different from the IPO lockup clause itself, but rather what is the rationale for locking up the shares at IPO. So the rationale that the banks and the regulators want a lockup is a couple of reasons. The first is you actually want to ensure that the existing shareholders and founders do not dump their shares immediately once the company starts trading. The second is that you want to maintain the share price for a period of time to ensure that the company's shares are stable.
Yeah, I will add here that what Hyok is talking about, referring to here, is that even if the laws of the country, IPO laws for the country does not have a lockup requirement, we advise founders to sort of consider whether to enter into a contractual lockup with the investors, such that they sign an agreement and agree not to sell their shares once for a certain period of time after the company goes IPO. So in this section, I'll be covering how to address due diligence issues that come up in the legal documentation in such a way that would not prevent you from closing the deal. So some general examples of due diligence issues are like missing incomplete corporate actions, non-properly executed documents, etc. And our general advice to founders is that due diligence issues should be resolved pre-signing and closing of the deal. Only if it's not possible, then we would look to addressing these in the legal documentation through these various methods: condition precedent, condition subsequent, pre-closing, post-closing obligations, representations and warranties, and even specific indemnities. So from the founder's perspective, if you were to put these clauses in the documents, then if these clauses have not been fulfilled for whatever reason, then you may open yourself and the company up to legal liability. However, in some cases, we do see that time sensitivity may be a factor because, for example, regulatory filing would take some time to be cleared with the regulators. So if you want to prevent delaying closing, you can, as an alternative, address these as in the legal documentation instead. So now to sort of explain what these are. Sorry, has the slide jumped? Sorry, we are having some technical difficulty. Maybe you could restart this presentation again. Sorry, give us a minute. It seems to be some issue.
While we were waiting for the thing to restart, maybe there's a couple of questions people were asking. You're talking about lockout. I don't know, this one probably is for Hyok. If VC are subject to a lockout at IPO, are founders and employees bound by lockup agreement as well? I think this is for Hyok, I think.
Okay, thanks, Hilok. Yeah, actually, VCs are subject to lockup, and also founders and employees themselves will be subject to lockup. So it will be the regulators, listing rules, and investment banks would require the founders and employees to be subject to lockup. Maybe not the regulators and listing rules, but more the regulators and listing rules will require the founders if they own a certain percentage of shares, but rather the investment banks will want the founders and employees to be subject to lockup as well. And the implication, of course, is that, yeah, as a founder and as an employee, you cannot sell your shares until the lockup expires. So it will be 180 days for US IPOs and for SGX IPOs. And as mentioned earlier, the reason is really because they want to keep the share price stable at listing, and they do not want the founders and employees to dump the shares immediately.
Okay. I guess next question is probably for Kevin. What are the typical qualified IPO exit value? How would it be calculated?
Well, it's usually on 2 times or 3 times of the last round post-valuation amount. But in early stages, that's usually at the later stages of the company. Usually at the earlier stages, it will just be 1x. And with every new stage of financing, the QIPO amount may continue to decrease because obviously the post-money valuation will change.
Okay. I guess while we're waiting for the thing to restart, we can take a few more questions. I think this is probably for Hyok. Should I allow existing investors to participate in the IPO? I guess IPO buying shares. Yeah. Hyok, I guess for Hyok, right?
Yeah, you should allow existing investors to participate in an IPO because it helps to build the book for allocation of new IPO shares. But likely the bankers will want to reserve some shares or actually for their institutional clients and investors. So this is something that will have to be worked out with the bankers. And you should also consider there could be public float requirements for the stock exchange, meaning that there must be a minimum amount of shares in the hands of the retail investors. So this is something that will have to be worked out.
Okay, I guess we are back on the screen. Maybe we can continue. Kevin, I guess you can toggle.
Yep. Sorry for the technical issues. Okay. So now I will sort of explain what are all these terms about. So first off is on condition precedents. As the name suggests, they are basically conditions that the company has to fulfill before the parties can proceed to closing. So if all the conditions are not fulfilled, then parties will not be able to close the transaction. And then next will be condition subsequent, and it's obviously conditions that the company has to fulfill after closing the transaction. And likewise, if it's not fulfilled within the time period that after closing the transaction, it may potentially unwind the whole deal. And next is on pre and post closing obligations. These are sort of alternatives to conditions precedent and subsequent, whereas compared to conditions, they are just obligations that the company has to fulfill before or after closing. But if they are not fulfilled, the main recourse for investors would be to sue the company for compensation, but it will not kill the deal. Next, on representations, these are basically, as Hyok covered earlier, representations about the business of the company. But in certain cases, specific representations may be requested for by the investors for known due diligence issues, but typically of lower sort of probability of becoming an area of contention, and the founders are comfortable that would not lead to the company being liable or sued. And the last one is specific indemnity. This is usually used for known monetary liabilities such as regulatory fines or maybe estimated costs for losing a lawsuit. And then the company would have to compensate investors on top of paying the monetary liability if it eventuates. So in terms of how to think of all these together, so we arranged it in terms of the severity of issue. When the investors think about the issue, the due diligence issue, for the most fundamental issues, they will always ask the company to resolve before they even sign the documents. And for the least severe ones, they would usually put it in the documents as a representation and warranty, or even as a specific indemnity. Condition precedents are only usually used for critical issues that may actually may affect the investment value for the investors. Whereas for condition subsequent are usually used for fairly important issues, but may not affect the investors' investment value and will usually take a long time to resolve. So one thing to take note for all these various forms of terms is that investors would always ask for proof and evidence that these issues have been resolved. So to avoid any delay, we always advise founders to always have these documents ready or ask for these documents to avoid any delay. And now we will cover from the founder's perspective, what is the general rule that we typically advise founders on. So when it comes to conditions precedent and conditions subsequent, we will always recommend keeping the list as short as possible, because this could prevent successful closing of the transaction, and there's also administrative burden of keeping track of all these various conditions. And we also would advise founders to negotiate for an option to waive in the event that these obligations cannot be fulfilled in the event of any unforeseen circumstances. For pre and post closing obligations, these will not kill the deal, but just bear in mind, as mentioned, it may open you up to legal liability. So you should also ensure that you keep this list as short as possible. For representations and warranties, we would advise keeping it to the minor ones, especially for any specific reps and warranties that the investors may ask for, including those that may not affect the business materially, because the longer the number of representations you give to the investors means the more potential liability you may be open up to. And usually for reps and warranties is a long list of terms and clauses, and it's a potential minefield because you never know when in the future you may be actually sued on these terms. So because if any of them are slightly untrue, as you have mentioned, we advise disclosing in the disclosure letter or otherwise qualify with some quantum threshold. And then this would basically be sort of a disclosure against these representation and warranties that the investors would sign, and they would sort of acknowledge that they are going in eyes wide open into this deal despite these breaches, so-called technical breaches of the reps and warranties. We also recommend that founders should delete the non-standard representation and warranties to avoid any onerous liability. Next, on specific indemnities, we recommend keeping this list as narrow as possible. These terms as narrow as possible to reduce liability, because these specific indemnities are basically the company and the founders agreeing that there's this potential monetary liability that may actually eventuate, and that you agree that if it does actually come about, you would pay the investors for this amount of loss that the company has suffered. So take note, for breach of reps and warranties and specific indemnities, these may lead to actually cash having to be drained out from the company to be repaid to the investors, and especially for a breach of reps and warranties. So do take note when you go through the list of these reps and indemnities. Sorry.
I guess we have time for a couple more questions. So I think one of the questions I suppose is for Kevin. Is what is my right of recourse if I'm unable to fulfill the conditional precedents and the investor pull out of the investments?
To avoid delaying the deal closing and the investor backing out, I think the first resort for you to try to negotiate for it to be waived, or to push for this condition precedent to become a condition subsequent instead. But if it's included as a condition precedent, in most cases we see that it's likely to be very important to the investor. So it's quite unlikely that the investor will agree to waive it. Hence, the likely option is to negotiate to push it to as a condition subsequent. And hence, that's why, as we mentioned earlier, it's important to ensure that you only include CPs that you are confident of fulfilling, and always to keep it as specific as possible.
I guess next one is for Keong, probably relating to the earlier session. This is relating to the variation clause. What is the usual threshold for the variation clause? You're mute. You're mute. Yeah.
Variation clause, there's actually no fixed industry standard on the percentage threshold. If you go by percentage, maybe we see more commonly, of course, in the earlier stage round financing, you could see a bigger percentage, but later round you will see a smaller percentage as you grow into later rounds. But perhaps one way to think about it is to actually go by every major investor. So the term major investor will be required to agree to the variation of the clause. So then major investor will be actually defined in the SHA itself. But of course, note that there's a distinction between lead investor and major investor, meaning a lead investor is always a major investor, but there could be a few major investors in each round.
If I can add, one other way of thinking about it, I think, is if this investor has been actively participating in your business and has been contributing to your company, Whereas those shareholders who are sleeping shareholders, you may not want them to have so much rights and say. So maybe you want to set the threshold at a level whereby these sleeping investors are not able to sort of have so many rights and not able to sort of block any variation of the agreement.
Okay, there are quite a lot of questions, so I'm going to just go to some of the, I guess, more, pressing questions. There's another one which is, I guess, more relating to COVID. With the current COVID situation, how does it really affect the deal closing and financing?
Okay, so on deal closing, I think this is a good question. It can affect your deal on a matter of ways. So first, I think the most obvious one would be the material adverse effect clause, which is found in most transaction documents. So prior to COVID-19, it actually broadly covers acts of God, but the definition is usually very broad to cover mainly events like earthquake, tornadoes, etc. But since the definition is so broad, it would really be a matter of interpretation as to whether it will cover an event like COVID-19, and this will be up to the courts to decide. But moving forward, it is likely that people will more closely scrutinize this definition and will ask for global pandemics to be included. Hence, it's advisable, to close your deals as quickly as possible, and so that because the MAE may potentially be used as a bargaining chip to sort of renegotiate the valuation and the whole deal. I think another point to sort of consider also, other than the MAE clause, is the as in regarding deal closing, is CPs, CSs, and your representations and warranties, because due to the lockdown and everyone having to work from home and processes have slowed down, you need to consider whether you will be able to fulfill all your conditions and your obligations in time. If not, you may need to consider renegotiating the CPs to the CSs, or whether the time frame for the CSs are long enough. You have enough time buffer. Whereas for reps and warranties and various other pre-post closing obligations, due to the impact of COVID-19, will these reps and warranties still be true and accurate? Example, the warranty that there's no material impact to your business since the last financial year end, or whether the obligation that there is no material impact to your business between the signing of the transaction documents and the closing of the deal.
I guess next question is a bit tricky. I guess we should ask this question, but I guess Hyok can go first, and maybe Kevin can also. It's about listing in US versus listing in SGX, which is a better option. And I guess we are relating to technology companies because we are in the technology business. So I guess the question is, for technology company startup, eventually, is it better to be listed in the US or Singapore Stock Exchange, which is a better option? Maybe Hyok, you want to start first, and Kevin can say.
Yeah. So, okay, this is a good question. So the benefits of actually listing in the US compared to the SGX is, I think the main benefit is you're likely to get a higher valuation because in the US markets, there's huge trading volumes and there's easier access to a larger pool of investors. The second advantage, of course, is that the US is less stringent on maybe loss-making companies. So as a tech company, you are likely to be loss-making in your earlier years. So this is something that the US stock markets are a bit more open to this situation. But of course, the downside the disadvantages of listing in the US is that the compliance portion will be more complicated because it's further from home, and as a Southeast Asian company, this is something that you have to take into account as well. And the last potential disadvantage is the listing costs. So the US investment bankers and lawyers will charge a lot more compared to a listing here.
Yeah, I guess I will just chip in and add that, I think liquidity is a key consideration for deciding where you want to list. So back when I was still working at A&G, I did a lot of privatizations of listed companies. And one common feedback that I got from them as to why they decided to delist is because the SGX is a bit illiquid. There are not enough retail investors trading the shares, so the volume is low and the price does not fluctuate much or increase much.
Yeah. So next one, I guess, is about what's reps and warranty insurance. The question is, what is the reps and warranties? I get W&I insurance, and when do people use warranty and indemnity insurance? I guess this one should be for Kevin, I suppose.
Yeah, I think I'll take this one. Maybe just to first explain what is warranty and indemnity insurance for everyone. Warranty and indemnity insurance is basically an insurer coming in to sort of insure the sellers for any potential liability for a breach of their warranties as well as indemnities. And this is usually used in M&A transaction. It's not so commonly found in fundraising, but more for exit M&A. So sellers, meaning the founders and existing share investors, will negotiate with the buyer and the insurer for the insurer to take over liability. Then sellers and buyers would agree on the insurance premium, and also on the and they will usually agree to share the costs proportionately based on whatever proportion they agree. And the insurer will, in the process, the insurer will do the due diligence on the company and decide on what's the insurance coverage they can offer and the amount of coverage they can offer for various warranties and indemnities. And they might sometimes even carve out some of the warranties and indemnities from the coverage if they're not comfortable with the potential liability. So to answer this, I guess the second part of the question is this insurance is most commonly found actually from what we've seen in the private equity space, because the transactions are typically larger in monetary value and the premium costs involved may be more justifiable and proportionate to the size of the deal. And sellers would want to use this insurance because they want to have a clean exit from the company and no further future liability. Meaning once they close the deal, there's no risk of the buyers coming back and suing the sellers for a breach of warranties and indemnities. I mean, unless there's any fraud or misconduct on their part. But I would mention that we do see that this warranty indemnity insurance is starting to gain some popularity in the VC space, especially Southeast Asia, with the growing number of unicorns and later stage startups.
I guess we will take a last question. This perhaps is for Hyok. There's questions about at which stage of the investment stage should we start including the IPO related clauses into the agreement?
At which stage of the investments are you supposed to include the IPO related clauses in the agreement?
Yeah.
This is not there's no fixed rule as to when you should include IPO related clauses. Perhaps it's usually not. Perhaps the standard is usually not in the earlier stage financings, but maybe when you go to slightly later stage, then this is something that the lawyers or the investors will ask for it.
Okay.
Yeah. I think most commonly for Southeast Asian transactions, from the first stage you raise an equity round, we will see all these US related IPO clauses because these are the rules in US. So you'll see all these terms governing the piggyback registration rights, the procedure, the timeline, the demand registration rights, the timeline, the procedure, everything will be set out in the documents from the first stage. And it's usually fairly standard because it tracks the US listing rules. So usually this is not an area of contention when it comes to the legal documentation negotiation.
Okay. I guess with that, maybe perhaps Cheryl, you want to bring up the slide? Well, with this, I guess we will come to the end of the session. Sorry that again we seem to have a lot more questions. We are unable to answer some of them. Sorry for that. But nevertheless, we would like to remind everybody next week is 1 week break for us. Thereafter, we will continue after that on October 2nd. There will be a session number 7, which we have invited a couple of very good entrepreneurs to talk about. Making sense out of artificial intelligence. This is one of the topics that everybody talks about every now and then. We got a couple of very good speakers, including some of the Vertex team who have spent time looking at this sector quite a bit. And so do sign up for it. And it will be 2 weeks from now, Friday, and it's talking about artificial intelligence and making sense out of that. With that, thank you very much for participating, and thank you, Hyok and Kevin, for presenting. Thank you very much.
And everyone, please feel free to reach out to Vertex or to Hyok and myself separately if you have any further questions that you'd like to discuss and ask us.
Yeah, thanks everyone.